Good evening and welcome everyone who is joining us for this evening's virtual town hall on the pardons process in the criminal justice system. We welcome you today. The criminal justice system oversight and reform is a key focus for the NAACP, both on the national and local level. It is one of the issues identified as game changers in NAACP's strategic plan. The criminal justice system includes law enforcement, the courts, and corrections. As the national NAACP states, we advocate for smarter results based on the criminal justice policies. In comparison with other countries, the US is home to 5% of the world's population and 25% of the world's prison population. This is a high number of incarcerated people, and yet incarceration has not kept communities safer. We need treatment for addiction and mental health problems, judicial discretion in sentencing, and on end the racial disparities at all levels in the criminal justice system. The negative impacts of incarceration on a person, the family, community are well known. Tonight, will focus on an aspect of the criminal justice system which can reduce negative impacts, that is pardons and expungements. We urge you to join NAACP Lancaster branch. We are the oldest civil rights organization in the United States of America. We also welcome everyone that is here. We welcome our speaker who has been here with us many, many times, Blandon Flood. This is our sixth session on pardons. And we hope that everyone finds tonight's virtual hall informative, and you are allowed to ask questions. And the moderator this evening is Cedrick Kazadi. Cedrick is a part of the generation of social justice leaders. He's a member of the Millersville University chapter of NAACP, and Lancaster NAACP oversees two college chapters, E-Town and Millersville. We welcome Cedrick, who will introduce our guest speaker this evening. Thank you, and we hope that you also take the time out to learn about the NAACP, and we also welcome your feedback and our program, as well as some of the advocacy work that we are doing around Lancaster County. Thank you very much, and I will pass this on to Cedrick. And if you have any questions as well, please put them in the Q&A box, in the chat box as well. So if you have any questions, you can direct them to the moderator. Thank you very much, and we welcome you.
Good evening, everybody. My name is Cedrick Kazadi. I'm the Millersville University NAACP College Chapter President, and I'll be the moderator for the event today. As President Blandon said, please feel free to put your questions in the chat box as we go throughout the event. I'll make sure to get your questions out to our guest speaker. Please be mindful that we have a lot of questions going on. So if we don't get to your question, we will try our best to get to your question as we go throughout the event. With that being said, I'm going to pass it on to our guest speaker, Mr. Blandon Flood, who's the Secretary of the Board of Pardons, Commonwealth of Pennsylvania.
Hey, thank you for that introduction. Blandon, again, it's always a pleasure, man, to be able to present before the residents of Lancaster and Lancaster County. You know, I'm famous for saying that the Lancaster NAACP branch is heads and shoulders above the other branches across the state, and that's no slight to the other branches. It's just that this branch in particular is working a little bit harder. That's all. So. That said, as was mentioned, my name is Blandon Flood. I serve as the Secretary of the Pennsylvania Board of Pardons. And so two things. Number one, what is the Pennsylvania Board of Pardons, and what is my job as Secretary? What does that consist of? So the Board of Pardons, our agency, exists for the purposes of administering what's known as executive clemency. And the executive clemency in Pennsylvania is defined as the executive branch, which is the governor's office. It's the executive branch. The executive branch's ability to extend mercy or forgiveness to anyone that's been convicted of a crime in Pennsylvania. So think of executive clemency as the umbrella term, mercy and forgiveness for anyone that's been convicted of a crime. And then, so clemency is the umbrella term, but clemency is made up of two parts. Pardons is the one side of the coin. That's the one that most folks are familiar with. What a pardon does is it allows you to have your record removed, cleared. So it is as if you never have been convicted of a crime. So receiving a pardon in Pennsylvania is literally like the reset button for anyone that's been convicted of a crime. or criminal offense, I should say. So that's one side of the clemency coin, pardons. And then the other side of the coin is what's known as commutations. And commutations is defined as the modification or the reduction of one sentence. So think of someone who's condemned to death row who wants their sentence modified to life without parole. Think of someone who is that has been sentenced to life without parole, which in Pennsylvania means once a natural life, who wants their sentence modified to life on parole. Or think of someone who's been excessively sentenced, where the penalty isn't commensurate or equal to the punishment, or whether the punishment isn't equal to the crime. So that's what executive clemency is. Mercy, forgiveness for anyone that's been convicted of a crime, made of two parts, pardons, commutation. So that's what executive clemency is. So what is my job as secretary? So my job is, I serve as the chief administrator of this process and this agency. So my job is to direct obviously the receipt of applications, processing, the intake of applications, the vetting of those applications, sharing information. This process is very much a victim-involved process. So ensuring that notification is sent to all interested and deserving parties. And then obviously preparing the cases for the board to be able to review. So as secretary, I am not the final or the final arbiter when it comes to these cases. There's a 5-member board that I answer to and that I report to. And more importantly, it's that 5-member board that actually votes on those applications. So my job is to prepare for them, schedule the hearings, also to drive the policy, right? So I'm the person that sets that, as well as with our lieutenant governor, who sets the policy for what our board is adhering to. That can range from anything to what our actual application looks like, to what information our board should be considering, how they should be reviewing cases, how we schedule cases. So I have a lot of latitude in the sense that I can create a lot of, or at least propose a lot of changes to this process. Part of the reason why I was brought on was to make this a more efficient process. The Board of Pardons is not a new agency. We've been around for 150 years. It's just that the executive clemency process has been one that has been a very complex one, and one that has been kind of cloaked in a lot of mystique, right? So most people used to, historically felt that you had to be either well-connected or have someone in government in order to receive executive clemency. That may have been the culture in the past, but certainly that is no longer the case. It is about merit. At least that's the philosophy that at least I'm running this ship under. So that's what my job is as secretary. I'm the person who oversees this process, but I report to that 5-member board. So let me tell you who's on the board. So the Constitution provides for who serves on our board. So the Constitution is very clear in stating that the Lieutenant Governor has to serve as the chair. So he's the chairman. He's the person that oversees the board. And then it also says that the Attorney General of Pennsylvania also has to serve on the board. So those two, both the Lieutenant Governor and the Governor, serve on the board for as long as they hold their respective office as Lieutenant Governor and Attorney General. Then the Constitution more broadly states that there has to be 3 other board members that must have expertise in the following areas. So there must be a corrections expert, there must be a psychologist, and there must be a victim representative. Those 3 board members, and I've seen one of the questions come through, those 3 board members are appointed by the governor, and they serve 6-year staggered terms. But as I said, the other 2, they serve for as long as they serve, as long as they hold their respective office. So that's who votes on the application. So what I'm gonna do is I'm gonna talk a little bit about process. I'll talk about some of the changes that we've made. And then, I'm more inclined to defer to questions and answers, because I know a lot of people that usually tune into this, they have more questions than commentary or comments. So let's talk about process. So one of the things that we changed immediately is we made this process a free process. So again, one of the mistruths or half-truths you probably used to hear about this process is that it's a very expensive process. And I call it a half-truth because it only used to cost $63 if you proceeded on your own. but it was so complex that you felt like you had to outsource it to an attorney. And what happened is once it got to the attorney's hands, they would mark up the price from so that $63 would jump up to $5,000 or $7,500, right? And most of us don't have that kind of pocket money, don't have that as pocket money. So a lot of people deserving people like that did not have a chance or felt like they didn't have a chance to take advantage of this process. So we got rid of the fee, and then we completely revamped the application. I call it a living document because we're constantly fine tuning that application to make it as simplified as possible. So we made that document very simplified. Previously, it used to be very intimidating document, a lot of legal jargon, a lot of terms that the average layperson weren't familiar with. So they found that difficult to navigate. So we simplified it. We reduced, almost cut it in half in terms of the amount of pages that were necessary. So what happens? So it wasn't enough for us just to get rid of the fee, but to simplify the application so folks don't feel like they have to send it to an attorney. The other thing we did is we created a video tutorial too. You can literally go to our website, www.bop.pa.gov, and you can see there's a video tutorial that literally walks you through each section of the application. The purpose of us creating that tool was to be able to, again, we wanted to make this process as foolproof as possible. So with the less corrective action that the applicant has to take, or the less time we have to spend on communicating to that applicant that they need to take corrective action, the more time we can be spending on actually processing these applications. So if you go to our website, that video tutorial is there for you to use and to guide you through that process. So let me back up a little bit because I jumped a little bit ahead and talked about some changes. Someone asked about the repeat of the website. I'm going to task both Blandon and our MC, if you can please provide my email address, bflood@pa.gov, as well as the website, www.bop, as in Board of Pardons, .pa.gov. So process, how does it work? So literally all you have to do now is if you go to our website, you can download a copy of the application. If you have Adobe software, you can actually fill out the application on your computer, but you'll have to print out that application. Right now, we are in the very much in the middle towards about 3/4 of the way through digitizing this process. So we're going to be transitioning to an online platform where you can literally fill out and submit your application via your smartphone or handheld device. We anticipate being able to roll out that capability by the end of this year, but no later than February of 2022. At least that's our current projections. But as of right now, until we transition into the online platform, all applications have to be printed out and sent via hard copy to us. So you'll go to our website. We have instructions on how to fill out the application. You heard me talk about the web tutorial. You will fill out that application depending upon which court your case was disposed in, meaning whether it was on the magistrate level or the municipal level, or whether it was through the common pleas court. There's certain court documents that you have to get. We have those outlined in those the application instructions. Literally list which specific documents you need from the court. Some courthouses may charge you a photocopying fee. I'm from Dauphin County. We were able to strike a deal with our clerk of courts here where they don't charge photocopying fees, but you may incur a cost for photocopying fees. But the most difficult part of this process in terms of applying for a pardon or commutation for that matter is literally getting those court documents from the clerk of courts. And that's not even as difficult as it used to be. Literally, all you have to do is call the clerk of courts. You tell them which dockets. So whichever docket you're looking to be pardoned for, you will call the clerk of courts and say, hey, for docket X, Y, and Z, I need the following documents. They're familiar. The clerks at the front desk are familiar with what you're asking for. They'll put it together for you. And literally, all you have to do is cop and roll, right? You grab and go. That's all you have to do these days. So, and part of, a lot of the changes that we were able to make is just through strategic partnerships, right? So, every year, especially prior to COVID, I made it my duty to go to the Clerk of Court and Prothonotary Association, the state association, to their annual conferences, because all of us work in conjunction with each other. The clients that we serve have to go to the Clerk of Courts and have to get these documents. So it only makes sense for us all to be on the same page. So I go to those conferences every year just to let them know, hey, here's the things that are changing on our end. Here's requests that you'll receive and that you should become familiar with. Here's what potential clients will be asking you for. Here's how to respond to that. That way it can be a seamless process. And I'm proud to say that I have a great working relationship with the State Association of Prothonotaries and Clerk of Courts, and we look forward to further fortifying that relationship. So that is the most difficult part of this process, obtaining those court documents, which, as I said, isn't really difficult at all. So once you get those court documents, you fill out the application, you send it to us. It's literally that simple. Right now, just due to the sheer volume of applications that we're receiving, it may take between 3 weeks and a month for us to acknowledge receipt of your application. So the first correspondence you'll get from us is saying, hey, we received your application. In the event you made errors, we would notify you. We're a little bit better now. We're trying to, instead of telling you guys to take corrective action and change things, I'm of the philosophy that it's much more efficient for us just to make the changes on your behalf as opposed to the back and forth. So maybe about 3 weeks to a month after you send your application in to us, we would notify you that your application is received. So it's important to be mindful of these terms here too. So receipt, your application being received is different from your application being filed. And I'm gonna tell you what the difference is. Your application being received simply means we initially have gotten the physical copy of your application, and we take that application, we do what's known as a detailed review. So we're reviewing to make sure everything's accurate in there. We're matching up some of the answers with what you say, with what we find on your rap sheets and other court documents, and then we file your application. So an application being received and filed are two different things. So after we receive your application, we do that detailed review, we file your application with your district attorney, your president judge in the county where you were convicted of, and then probation and parole, who by law, they conduct our background investigation. So probation and parole, then we pass the ball to them, they do their thing, and then they provide us with a report. Once we get that report, we do an analysis of that report, and then we schedule you for what's known as a merit review hearing. So merit review hearing is much like a preliminary hearing in the judicial sense, meaning that this is a hearing that is meant to, much like the name suggests, this is a hearing just to determine whether your application merits you getting a full public hearing. And the full public hearing is the one that's for all the marbles, and that's the one that the board will vote to recommend or not your application to the governor. So when it comes to that merit review hearing, how it works in terms of voting protocols, unless you are sentenced to life or death, or you're incarcerated for a violent offense, you only have to get 2 out of 5 votes during the merit review in order to get a public hearing. So if you're not sentenced to death, life, or incarcerated for a crime of violence, 2 out of 3 votes. If you fall into any of those aforementioned categories, those 3, then you have to get 3 out of 5 votes. Typically, we schedule public hearings about 30 days after our merit review hearings. Merit review hearings, you don't have to show up. Essentially, what our board members, they're essentially assessing you based off of your application alone during the merit review. However, when you get to the public hearing, you may be required to appear virtually. It used to be prior to COVID, every applicant had to come in person. We've changed some things policy-wise, obviously with COVID. We can't do in-person hearings. So now we switch to an exclusively online or virtual platform. So we hold our hearings via Zoom. You can go to our website. We also, if you're not familiar with Zoom, we have a tutorial of how to navigate Zoom and how to appear for your hearing. But one other cool policy change that we recently made is, again, part of me being brought on was to make this process more efficient. So it used to be, as you heard me say, every applicant had to appear in person. It didn't matter how long ago, doesn't matter how minor the offense was. And for me, I found that to be, not only did it inconvenience the applicant, because we literally had applicants traveling from Seattle, Washington to Harrisburg for a 3-minute hearing. for a case that we knew without a shadow of a doubt that the board was going to recommend and that the governor will ultimately sign off on. So what I asked my board to do is I said, hey, let's make these votes matter. So when we have these merit review hearings, if we have cases, especially cases involving nonviolence, non-sexual cases, if individuals during those merit reviews are getting 4-1 votes or 5-0 votes, there's a clear indication there that that person doesn't need to appear for a hearing. They should, on the merits of their application, how much time has passed, or just how compelling that their application is, shouldn't have to appear. So that's one change that I got my board members to embrace. So if you are a nonviolent, non-sexual case and you get a 4-1 or 5-0 vote during merit review, you don't have to appear for a in-person hearing. And part of the way I was able to get our board to adopt that policy is the numbers. The numbers supported that. I looked over the last 3 years, how many people that were nonviolent, non-sexual, who had 4-1 or 5-0 votes, how many of those applications actually made it to the governor, and how many times did the governor sign off? And all of in every single case, each one of those applications made it there and made it to the governor, and the governor signed off on it. So depending upon your case, you may not have to appear. So when you get to public hearing, the voting protocols change a little bit. If you are sentenced to life or death, you have to obtain a unanimous vote. So you have to get 5 out of 5 votes if you are sentenced to life or death. If you don't fall into either of those categories, you only have to achieve a simple majority. So that's 3 out of 5 votes. To get the 3 to 5 votes, we then recommend your application to the governor. Pennsylvania is a little bit unique in that we have what's known as a gatekeeper system. There's a lot of states where simply the executive branch determines who's issued clemency, whereas Pennsylvania is unique, being that we have a board that has to, per our Constitution, our board has to recommend any application that the governor can sign off. The governor here in Pennsylvania can't unilaterally issue a pardon to someone or clemency to anyone, unlike some other states and unlike how it works on the federal system. I know many people, especially over this last election cycle, the last administration, the presidential administration, we became familiar with the president's pardoning powers, and those are very distinct from Pennsylvania. We have that gatekeeper system. So when your application is recommended to the governor, there is nothing in law that says that the governor has to act within any specified time period. So the governor can decide to wait 2 weeks. He can decide to wait 2 years. The governor can actually decide to leave office and not act on an application. However, both the governor's office and our shop are working more collaboratively to make sure that those turnaround times are not only more or faster, but that they're more uniform, right? So people can have a reasonable expectation after their application is recommended when they can expect to receive a response from the governor. So that's how that process works. And I want to back up a little bit, and then I'll talk about how. So I want to talk quickly about the civil rights that a pardon restores, and then I want to talk about how, once you receive that recommendation, once the governor signs your application, what that really means in practice in terms of how your criminal history can be used against you, or not be used against you. So let's talk about the civil rights that are restored. So one of the big misconceptions in Pennsylvania is that if you are convicted of a crime, most notably, if you're convicted of a felony, that you're not able to vote in Pennsylvania. That's false. It used to be the case. You used to have to wait 5 years after you were released from confinement in order to vote, but now your right to vote is restored immediately upon your release. And you're also able to vote in Pennsylvania if you're under what's known as pretrial status. So if you're awaiting trial and even if you're incarcerated, you can actually vote via absentee ballot. So that's a civil right that is now restored by default once you're released from prison. But some of the civil rights that are restored with the pardon are, number one, your ability to legally answer any question that any inquiry about your criminal history. You can legally answer on any application that, no, I've never been convicted of a crime, because that is the power that a pardon provides. It provides you with the ability to overcome the former disability of being convicted of a crime. So that's the first civil right that's restored. The other civil right that's restored is your ability to purchase and possess a firearm. I know that's something we've seen, especially post-pandemic. A lot of people have applied for pardons because they want to be able to purchase a firearm, or in their attempt to purchase a firearm, they ended up being flagged and told that they had something on their record. So getting a pardon allows you to be able to legally purchase and possess a firearm and be able to have that concealed carry permit. It also allows you to travel internationally. There are some countries that won't admit you entrance into their borders, most notably Canada, depending upon the conviction you have. Being able to serve in the military, the pardon allows you to overcome that disability. There are certain branches. I know that the armed forces are very stringent when it comes to felony convictions. Pretty much any felony conviction would render you ineligible, but a pardon allows you to serve in the armed forces. The other right that's restored, and one of my favorite rights, is the ability to serve on a jury. For those of you that aren't familiar with my story, I previously served 9 years in the Department of Corrections and ultimately received a pardon myself from the governor in 2019. So I've always been on the other side of the jury as a defendant. So I think it's cool. I'm looking forward to serving on a jury as a jurist this time, right? So that's a civil right that's restored. And then lastly, and also a civil right of mine that I actually petitioned for in my own personal application, the ability to lawfully run for and hold public office. There are certain criminal offenses that render you ineligible. Any infamous crime, which the courts have defined as being any felony offense, and also any offenses that are classified as crime and falsi offenses. So any crimes relating to fraudulence or deception, those can potentially render you ineligible. So those are the civil rights that are restored once you get a pardon. And then lastly, before I turn it over for Q&A, let's talk about what happens after the governor signs your pardon, because it does get a little bit complex somewhat, but at least some people view it as complex, but it's really simplified. So what happens is once the governor signs your pardon, he sends it to us. He sends us what's known as a charter of clemency. It's that charter of clemency. It's a piece of paper with the gold seal coming from the Secretary of the Department of State saying that, hey, you've been pardoned. You've received executive clemency from the governor for these offenses. Now, the way it works currently is when we issue that charter of clemency, we notify the state police and the FBI that you've been pardoned. So in their system, if there's any subsequent inquiries that are made to either the state police or the FBI, nothing will come back in terms of your criminal history. That happens automatically. However, what doesn't happen automatically is the actual records themselves aren't destroyed or expunged. Technically, you would still, if you want to destroy the record so that technically the physical or digital copies aren't in existence anymore, then you would have to go through with the expungement process, and you have to file a petition at your own expense for that. However, there was a bill passed at the end of October of 2020, which the bill was marketed as automatic expungement. So it was automatic expungement for people that were exonerated of crimes. But if you look into the fine details of the bill, it didn't extend automatic expungement to people that received pardons. It extended essentially automatic sealing. So sealing is different from a pardon sealing is different from expungement because the sealing just limits who has access. Whereas, as I said earlier, expungement actually gets rid of the record in its entirety. So what sealing does is, for any of you that are familiar with what's known as the Pennsylvania Unified Judicial Web Portal, you can go on that website and look up docket sheets for free. That is what now will be removed. So if you go and look up my name right now, I didn't go through with the expungement process after I received a pardon. So if you go to that judicial portal, my criminal history, there's still dockets there that are still associated with me. But as it says on that website, that web portal, it's a disclaimer on there that says that the records here aren't meant to be used for official purposes because they don't really maintain those records very frequently. And again, you have someone like myself that may have received a pardon, but didn't go through with the expungement piece. So those records still stay there. And someone just put the link up for that web portal. So what the new automatic sealing bill does is it removes, so automatically what happens, we notify state police, FBI, you're good there. And then the automatic sealing removes the record from that portal. So essentially it is tantamount to your record being expunged, with the exception that those records actually still exist somewhere. So the difference between expungement and sealing, again, as I said, it limits who has access. Sealing limits who has access and how your records are used. Expungement gets rid of the record in its entirety. So we usually tell people when we send you that charter of clemency, give it maybe a week or two for state police to update their records. And then you're really free and clear. It is as if you push the reset button. You know, I even with myself not going through with the expungement process, I have my concealed carry permit and have been able to do quite a few lawfully purchased firearms myself, despite doing that. So your civil rights are restored upon receiving that pardon. So that's how it works, you know. And I know I didn't spend too much time talking about my own personal case, but one of the things I'm trying to be better about is kind of being more sharing more of those intimate details, because a lot of people that don't know me and I say, hey, I got a pardon, and they automatically assume that maybe I had something that was low level, or that I knew all the right people in government, so that's how I got it. And I like to say that I was a former 2-time felon, crack cocaine and firearms. And I was able to, as well as an extensive juvenile history, and I was able to right the ship and be able to at least put forth a pardon application that the board found compelling and was extended that clemency. So the same outcomes that I was able to achieve, those they're available to you all. I'm big on saying, and it's been proven to be the case, that 80% of the people that approach me or ask me about pardons are better candidates than I was when I put in when I submitted my application. So it's really just about, historically, it's really been about the lack of access. But as you can see, especially with Blandon doing events like this, we're opening access up. This is as transparent and accessible as the Board of Pardons has ever been in the 150 years of its existence. So again, Blaine, I'm going to thank you for convening this. And I'm happy to entertain any questions. There are no dumb questions. This is about enlightenment. So shoot them my way.
All right, thank you so much, Mr. Blandon. We're gonna go ahead and start up with the questions. The first question that we received said, how are people selected for the Board of Pardons?
Right. So as I said, the governor selects 3 board members. There's 2 board members that are constitutionally or kind of by default board members: the Attorney General, Lieutenant Governor. So they aren't picked. Whoever is elected to those 2 posts, they're board members by default. But those other 3 board members, it's the governor who appoints them, and they're appointed for 6-year terms. So it is a part-time board. They are paid about a little bit over $20,000, but it's the governor that ultimately appoints them.
Okay. Next question says, is there a cost for the copies from the clerk of courts?
Right. So as I said, depending upon which county you're in, they may charge you a photocopying fee. Obviously, I can't compel the counties to forego the photocopying fees, but I live and play in Dauphin County and from Dauphin County, so I have a better relationship with my clerk of court and was able to get them to forego the photocopying fees. But if it is a cost issue, you also can request those documents, and you also can invoke what's known as informa pauperis, right? So you can say, hey, I'm financially strapped and can't afford to pay for those photocopying fees. You would have to fill out a form and would have to apply informa pauperis. And obviously you would have to demonstrate some way, shape, or form that you are indigent or don't have the funds. But it varies by county, unfortunately. But Dauphin County, I can only speak for Dauphin County that they do not charge photocopying fees. Shout out to Dale Klein too, who's our clerk of court here in Dauphin County.
Next, this is a question in terms of statistics. The question is, how many applications for pardon do you get in a year, and how many are approved?
Right, great question. So, as I said, I was appointed a little bit about, well, actually, my 2-year anniversary just came and passed on the 1st. So, historically, we've never received more than 600 applications a year. This is prior to January 2019, when both Lieutenant Governor Fetterman came in and then myself. So historically, prior to that time, we never received more than 600 applications. We closed calendar year 2019. We had more than 1,100 applications. And then we closed out calendar year 2020, despite the pandemic, with more than 2,100 applications. So more than the 300% increase, and I only see the numbers trending upwards as we do more outreach and education. We have commutation specialists. I believe I seen George Trudell, who's our commutation specialist. He's on the call. So part of our job is getting the word out and getting more people apply. So I only see that number trending upwards. It should be 10,000 plus people applying per year. And real quick, the other thing too, if you're a stat person, if you go to our website, we do have, it's chock full of stats. We actually have a stats section where you can look by year, you can look by governor, you can drill down on some of those numbers. Again, if you go to our website, tons of information there, tons of resources.
I believe President Blandon has something to say. You can unmute yourself.
I didn't hear you.
Yeah, I said President Blandon, I believe, has something to say, but I think.
Oh, Blandon.
Yeah.
No, a hand was. Hello?
Yes, we can hear
you.
No, my hand was up by accident.
Okay. Okay, we're gonna move on to the next question. The next question says, if a person is denied, may he or she reapply?
Yeah, so the way that it works, if someone's denied, you have to wait a calendar year, 12 months from the date of your denial to reapply. That's the first time. If you apply and you're denied a second or a subsequent time, then you have to wait 24 months to apply. But we also have what's known as a reconsideration process. So what reconsideration does is, as opposed to you starting the process all over again and submitting a new application, if you're able to put forth anything new or compelling that may have emerged since your denial, that will, and depending upon what it is, that will allow you to be, at least for the board to vote on whether to reconsider your application. So instead of you starting over, you kind of start right back up where you left off. So yeah, as long as you're able to put forth something that is new or compelling that's emerged since your denial, obviously you can't just say you didn't like the decision. Then you can go through that reconsideration process as opposed to applying all over again.
Next question here says, I'm curious if the Board of Pardons has handled many protest-related convictions in the past year.
Protest-related convictions?
Yes.
Yeah, not that I know of, just because it hasn't been broken out. Obviously, I don't get to see all of the applications. Usually, I don't read all of the applications in their entirety, only some of kind of the more noteworthy cases or some of the reconsideration cases. But no, I haven't. But I would assume if they're protest-related offenses, they have to be somewhat recent, right? So we're talking about a year or two. And certainly one of the factors that our board looks at is how much time has passed since your conviction. So for someone that has a recent conviction, especially, well, any really conviction, if someone has a recent conviction, that may prove problematic. So there's really no set time that someone should wait before they put in. But the main thing that our board is looking at is what we classify as being demonstrable evidence that you've changed your life or you've been rehabilitated, right? So if you're able to prove that in a compelling way in 2 years, that's great, but not many people are able to do that. So yeah, no, more than likely we haven't seen a lot of the protest-related, or at least protest-related applications this year.
Next question is, so in terms of the process and how long it takes, There are people that can't get like a rental spot because they have a case that's pending and they're trying to get that pardon. Is there like a process that's being put in place to speed up the process? Because some people find themselves in situations where they can't get a job or end up being homeless because of how long it's taking. Is there anything that's being done in order to like speed up the process?
Right. No, that's a great question. So yeah, that's one of the changes that we've made and that we're continuing to make. That was something that I seen early on. I mean, what benefited me is, prior to this work, I worked for the General Assembly, and I did extensive amount of research on executive clemency in Pennsylvania, even before I put in for my own pardon. So now I was kind of aware of a lot of the inefficiencies before I even came into this post, was able to hit the ground running. But one of the inefficiencies, to the point of whoever posed that question, is that historically we've always looked at everyone's application the same, And to me, it doesn't make sense that we grant the same amount of time and energy and man hours to someone convicted of first-degree murder than that we would for someone that stole a candy bar from a convenience store 30 years ago. So the first thing that we're able to do is for marijuana-related offenses, part of being able to speed up these cases is I have to be able to get a consensus amongst my board members of, listen, every application, you're not going to get as much detailed information as you would for some of the other cases. So what are you comfortable with me taking away? So being able to strike that fine balance. So we did it initially with marijuana cases. So right now, the pardon process, especially due to the sheer volume of cases now, the increase, right now it's about a 3-year process. But for the expedited cases, the marijuana cases, we were able to process those cases within 12 months to 18 months. So what we're looking at, and we've done that for a little bit over a year with some success. So now what we're looking to do is we're expanding that to other offenses outside of marijuana offenses. In particular, we're looking at offenses, you heard me talking about time earlier. Really, I'm looking at cases that are 15 plus years removed from their last conviction. Those are the ones that I consider as low-hanging fruit, that I'm able to get our board members to say, hey, I don't need as much information for these. So we have expanded that so we can hear some of these other cases within a year and 18 months. But the other part to remember too is, obviously I need more personnel. We need more, we had, you heard me say we have more than a 300% increase in applications, but our staff complement hasn't increased with that, right? So that's more of a workload. So we have to be a little bit more innovative. And then more importantly, one thing that often gets left out is our board, right? Our board doesn't change. They still remain a 5-member board, a part-time 5-member board. So me asking them to do more is a little bit difficult. With less is a little bit difficult. So trying to find those, strike that fine balance and get that consensus. So, and our board members understand too. So we actually hear more cases per session than we used to before. And part of being able to do that is now that we were able to institute a policy where not everyone has to appear in person, now we can hear 200 cases per session as opposed to 130. So these little changes, these little administrative changes, are slowly chipping away at that timetable. But yes, we are expanding our expedited review process, and this is something that we're going to continue to do at least as long as I serve as secretary.
Thank you. Next question is from Olivia Smaker. The question is, can anyone come to you to start the process for pardon, or is it limited by county of residence?
No, that's a good question. So yeah, one thing that there's a misconception that only people convicted of that certain people convicted of certain crimes aren't able to apply. Technically, everyone, no matter what you were convicted of, no matter which county you're in, everyone can apply for executive clemency. I qualify that by saying, as long as your conviction was disposed of in a state court, meaning a court of common pleas, or on the magistrate level or municipal level, then we can hear your case. If it is a federal conviction, then there's a separate process that goes through the federal office of the pardon attorney. That's a whole separate process. But as long as you were convicted in the court of common pleas or municipal court, regardless of what county you're in or what you were convicted of, you can apply. Now, I should also say too, obviously, depending upon the nature of the offense, the bar may be higher, right? So one thing we get a lot of people say, well, were people convicted of sexual offenses, are they able to apply? They are. However, obviously, there's a higher bar to clear, and certainly, as I said earlier in my commentary, this is a very victim-involved process. So, it's a little bit difficult for someone to have their, to get an affirmative vote from our board, the more egregious the offense is, particularly if you have victim opposition, but it's not impossible. So yes, you can apply.
Thank you. This question is from Stephanie Thomas. And the question is, if a person is to give a character statement on the defendant's behalf during a public hearing, how long do they have to speak?
Right, so the way our regulations are set up, we say that we technically, an applicant can have up to 15 minutes. Certainly if the chair doesn't feel like they need 15 minutes, then they won't be granted that. But technically they can have up to 15 minutes. For us, really, letters of support are impactful in this process. I know in maybe some instances and letters, some people may feel like letters don't go far, but for our board members, they really do place a lot of stock in those letters, particularly letters from non-family members and non-friends, right? So objective parties, people who really can speak who essentially are putting their neck on the line or their reputations on the line for vouching for someone. So yeah, technically they can. Usually I try to coordinate that through myself, especially since we're doing hearings virtually. Really, we don't allow people to kind of, at least this lieutenant governor, our chair, really doesn't allow people to speak on someone else's behalf unless they're offering something that is just extraordinarily compelling or something that information that we otherwise weren't made privy to throughout this process.
All right, thank you. This next question is from an anonymous attendee. It's pretty broad, so I'll try my best to go through it. So the person said, thank you very much for your presentation. I have a family member who has a 20-year-old conviction for cruelty to animals for being in the wrong place at the wrong time. A friend brought him to a dog fight and he was trying to leave when a mass arrest took place. His lawyer told him to plead guilty and told him it would be a misdemeanor. He recently applied for a firearm license, now realizing he had a felony on his record. He was declined, and we even submitted an appeal. 1 year later, the county put out a warrant. Now he's being convicted of a misdemeanor for falsifying his statement. Where do we start with this process? Apply for clemency for the original felony first. And he got arrested, it says felony 3rd degree and misdemeanor 3rd degree. So the question is,
well,
yeah.
I mean, we have this happen all the time too. I've spoken extensively with my district attorney here in Dauphin County about this, because you have some people who felt, and this is what I said earlier, a lot of people during the pandemic who became interested in getting firearms, especially with a lot of the social unrest. They found out during that time that they had certain convictions that they either forgot about or just didn't know were there, or that they were graded differently than was presented to them by their legal counsel. But you have some people, so what I asked my district attorney is, I said, how are you able to separate those that knowingly lie on the application from those who genuinely may have forgot or just couldn't recall, or the offense was graded differently than what they remember? And he said that obviously for him, he said it goes by obviously how recent the offense was. Obviously someone who had a conviction from 3 years ago is more inclined to remember that than someone who was convicted 20 years ago. So that is something that our board looks at. We do get a lot of applicants who are applying for pardons because they, for not only the offense that triggered the falsification, but also the falsification. So for this particular person, I would apply for both. You're applying for the pardon for both the initial felony as well as the misdemeanor falsification charge. Obviously, you're going to have to contextualize in your application what happened and how there was an oversight, and that you weren't willfully being deceptive. But it's going to be up to you as the applicant to put forth a compelling argument that you weren't being willfully deceptive, and that obviously this was just a honest mistake, because they do happen and we have seen them and quite a bit.
Thank you. Tracking back to a question that was asked earlier in terms of how many applications do you get a year? There's a similar question, but this question is asking, what is the number of pardons do you grant per year?
That we grant per year. So that varies. I mean, it's I think last year was over 500. Was close to 600. So you heard me talk about once we recommend an application to the governor, sometimes the governor can sit on the application for months, or we can go into a whole new calendar year. So it's not really reflective of the year that he received the application, as opposed to when he may have responded or signed off on the application. But yeah, a little over 500 was last year. If you remember, I believe it was maybe 2 months ago, the governor signed about 301 WAP. So it really varies, but the number is increasing. It's certainly trending upward. And as I said, part of what we're able to do now is being that we excuse a lot of these applicants from having to appear. We can go through hearings quicker, and we can schedule more applicants per hearing. So that naturally will result in us having higher numbers of applications approved by the governor annually.
Next question here says, my husband has been incarcerated for 14 years. He has a second-degree murder for a murder he did not commit, or was that when it happened? Does he have to wait 20 years to file for clemency, even though he did not kill anyone?
Right, so that I want to clear something up too. So this is a commutation case. So usually commutation cases involve people that are incarcerated, in most cases serving life on parole, but there are some cases where someone's a numerical number that's, a pretty high numerical number, 50 to 100 years, which is kind of tantamount to life. So the question she asked about the 20 years to do this, does the applicant have to wait 20 years to put in? So Secretary Wetzel from the Department of Corrections, that's his rule. His rule is that typically he says he does not recommend any, so you can always put in, the applicant can put in even if they don't have 20 years. The real question is will Secretary Wetzel support the application despite that person not having 20 years? So 20 years served. So Secretary Wetzel, as his own, he's said himself, he typically does not recommend any application that is not where the person has not served at least 20 years. Doesn't mean that there's not always exceptions to the rule, but I want to clarify, even if that person doesn't have 20 years served, they can still apply. What made the adverse impact of doing that would only possibly be Secretary Wetzel doesn't support the application. And then obviously our board member does look at what Secretary Wetzel's recommendation is. So yeah, he can apply, but that's Secretary Wetzel's rule, but he's willing to make exceptions, I'm sure.
Thank you. Next question here, it says, if there's a victim in your case, will they have input on the board's decision, or will the board make a decision without consulting them?
Right, so yeah, as I said, this is a very victim involved process. So yeah, we very much involve victims as early as possible. So usually around the time that an application is being filed, we try to give notification to the Office of Victim Advocate. So yeah, we do. We consult with both the district, and that's part of the reason why we consult with, when we file an application, we file it with the district attorney, because we're not only seeking his or her input as district attorney, but also on the county level, the Office of Victim Assistance. If there's any victims registered with the county, he or she would be able to transmit that notice to them. And then we also consult with the Office of Victim Advocate, which is a statewide advocacy agency. So yeah, we involve them, and they do have a chance to weigh in. Obviously, we see more instances where victims may be opposed to an application, but surprisingly, there's more victims than folks may think who are actually supportive of a lot of these applications, because it is about closure for a lot of folks. It is about, we talk about restorative justice. It's just not restoring the defendant or the applicant, but also surviving family members or victims themselves. So yes, this is very, very much a victim involved process.
Thank you. So we have two more questions. So the second to last question says, how would the board view convictions for poverty charges? In other words, bad checks.
So property charges, like property damage?
Yeah, and it says poverty charges. And then in other words,
poverty.
Yeah, bad checks. So I think maybe they meant.
Okay. Well, I mean, it would depend again. How long ago did it occur? Is there a pattern too? So it's one thing for someone to say, "Hey, listen, I was in a tight spot, and I had to pass off this bad check to feed my kids." It's another where you have 10 of these right over the course of an 8-year period. So, in particular, our corrections expert on the board, he's looking for patterns of behavior, right? So, depending upon how many they are and how recent they are, and then more importantly, one thing that our board looks at is fines, cost, and restitution, right? So if you passed off a bad check and there's outstanding restitution, it certainly would help your case if your victim has been made whole and compensated. So it really just depends on those factors, but certainly we see quite a bit of them come before us and receive favorable decisions.
Thank you. And last question of the evening, it says, if anyone can afford a lawyer, does it help to do so? Are the applications that much stronger in general?
Right. Yeah. So George Trudell, he's famous as saying that, and this is no disrespect to attorneys, but again, we looked at this as an access issue. And we have reports. You go to our website, we have a tab that says study reports. It's a number of reports that look at race, look at the economic impact of pardons, how many people are applying, black, white. One of the things we were able to see, when this was just a preliminary study, we actually have a more comprehensive study that looks at race and pardon applicants. But there's more, despite all of us on this Zoom call knowing that Black and brown folks are more have been involved in the criminal justice system at a disproportionate rate than their white counterparts, right? That's an undeniable fact, right? Involved in the criminal justice system, incarceration rates, possession of convictions, disproportionate, right? The undeniable fact. But if you look, and we ran a 10-year snapshot from 2010 to 2019, there were more white males receive pardons than Black and brown folks. And part of that reason was access, right? Typically, especially from the economic standpoint. I'm sure a lot of the white male applicants that put in had access to attorneys, right? Folks that can put forth those compelling narratives for them and really put forth a robust representation for their client. Whereas for someone who doesn't have that, either they don't begin the process because they find it too complex, or they're not able to put forth a compelling application. So one of the things that part of us refining this process and simplifying this process is because we want it. I mean, we still love for our attorneys that provide pro bono services to help people with applications, but we very much try to discourage people from compensating attorneys from assisting them with this process, because to be clear, having an attorney does not improve your chances any, doesn't speed up the application, doesn't guarantee any outcomes. The only thing that can pretty much be guaranteed is your pockets are going to be a little bit lighter after they put your application in. But yeah, it doesn't really, like I said, and I probably shouldn't be saying this, but unless your attorney has a personal relationship with any of the board members, there's no other reason to be paying for an attorney to navigate this process. Everything you need is at your disposal on our website, or, as Blandon will tell you, I'm a very accessible person. George Trudell in my office is very accessible. He put his information in the chat. So yeah, unless you just balling out of control, don't. There's no need to get an attorney.
Thank you so much. That's pretty much it when it comes to question. I believe President Blandon has something to say.
All right, thank you. Thank you, Secretary Brandon Flood, for all the information and resources that you have given us today. We thank you for all the participants as well with joining us. And we thank you also for moderating today's event, Cedrick, President Cedrick, and all the things that you have done. We also want to welcome Brandon back in the future. We thank you, Brandon, for always being with us and giving us this very, very valuable information relevant to the criminal justice system and pardons process, which is very important, considering that, we people of color are disproportionately affected, in many ways relevant to the prison system. And we need to continue, obviously, to advocate and address those areas. And so the information provided this evening, we can definitely use it in our community in Lancaster. And the other thing is, too, is if you want to learn more about the NAACP Lancaster branch and wanted to learn more about our game changers and criminal justice being one of them, economics, education, health, and political action. And also we have youth engagement as well. So until the next COVID town hall, we also are doing on COVID vaccinations. One of the other things and areas that we are working on in Lancaster County. And you want to learn more about resources and how to even get vaccines, or even some of the education virtual town halls that we are doing, please tune in to our branch Facebook page and YouTube channel that we have. And we also partnered with TCP Network on a lot of things relevant to some of the game changers that we work on in the Lancaster branch as well. Until then, we ask for everyone to continue wearing masks, be safe, and continue to social distance.